We'll start. So basically, first we will just quickly go through the all the sections by the title, right?
Mm-hmm.
So mainly the Patent Act, we can say this patent law as a patent, the Patents Act 1970, which will be amended several times. Now, this patent Act covers all the sections, and the things which are in the sections format, they are not, they can, that the fixed things, we cannot change those things, or the timelines which are given into the sections that are also fixed. There is no lingering or the flexible timeline will be there into the sections. So the sections which covers the things which are permanent, we cannot much change into these sections. So if you can see into the portal of the patent office, then you also can realize that very few amendments are there which are come happens with these sections. Because for the amendment, if you anyone wants to take a amendment into the sections, they have to go to the central government, and if the central government will pass the things, then that amendment will come out. So for that, generally the amendment in the sections are very less, and the things which are given into the sections are almost the permanent things are there, while in the rules are the another part of the patent law. So it also known as the patents rule 2003. So the first rule comes into the 2003, then various time the amendments will be there. The latest amendment will be happen into the 2021, in the September of the 2021. So the amendment into the rules are easy because there is no interference of the central governments, and the most if any amendment is required in the patent law, then it will be in the form of the these rules only. So you can see that the many amendments are there with respect to the rules. Many timelines are given into the patent rules. They can be a flexible, that can be a change with respect to the time. If some new provisions will be come into the picture, then it will be added to this rules format only, right? So this is just the basic knowledge who can interfere into the amendment of the rules as well as the sections or the act. So, in this Patent Act, which covers all the sections, so in that mainly total 23 chapters are there, which covers the different sections in that, right? And total 163 sections are there. Some of them are omitted, but we have to remember the 163 sections. So first, you have to start with the preparation to remembering the section number with the title. So first, your exercise, I think you have received the mail of my material for this examination preparation, right? So in that one file is that Ready Reckoner 1. So that Ready Reckoner 1 and 2, which covers the blank pages in which the sections number have been written with the chapter number, and you can take a printout of that, and after that you will start writing this section with the title. So first exercise you have to do is that you have to remember all the section number with the title, as well as all the rule number with the titles. So what happen if any MCQ will be asked in the this first paper, then and at least by the number, remembering the section number and the title, you can also get some of the ideas, because the answers are already given into the paper one, right? Because it's MCQ related questions. So you will get a more idea if you remember all the sections with the title. So that is the first exercise for you. Then now they have given the sections in the sequential manner only when we are starting the patent related any exercise practically, right? So they have given the things in that inline manner only, so you can remember in that way also. Okay, first what happened, then what, and then what. Okay. So in this chapter 1, they have just basically they are covering the preliminary things, basics about the patent law. In that, the basic first section is related to the very general things. What this law is known as the Patents Act 1970. Then second chapter is very much important because it covers a lot many of the definitions and the interpretations. So that can be helpful when you are interpreting the things in the whole the act. So the section number 2 is the important. Then this section number 2 will be covered by the MRC by tomorrow. Then in the chapter 3, total 3 sections are there. In that, the 5th section will be omitted, and the section 3 and the 4 will be there. They are more particularly related to the non-patentable inventions. So the Indian patent law is comparatively very stringent as compared to the any other country's law. So Indian patent law have given the chapter for the invention which are not patentable under the Indian patent law. So that is also this, both the sections are very important. In the 4th section there is nothing more given, but this is related to the atomic energy, and if any invention which are related to the atomic energy, then that is not patentable as per the Indian law. But the section 3, that is very important because they have given the different type of the inventions in which they are not patentable. So that can be asked in the paper 1 in the MCQ format or in the multiple choice questions. Then it may be asked in the paper 2 also in the scenario based questions, that some client come to you, told that I have come up with some herbal formulation. So now can I apply for the patent or not? So as per the section 3K, traditional knowledge can be, as such traditional knowledge can not be patentable. So we have to give the scenario based things to in that paper too, that as per the section 3K that is not allowed. But if they have come up with some new preparation or the new formulation of that particular herbal formulation, if the as such haldi will be there or turmeric will be there, then that is not allowed for the patentable. Right? But if you extract some the oil from the that turmeric, then that oil is used for some different purpose that is not known into the traditional or the ancient knowledge, then that can be patentable. So you can give the scenario in the scenario based question, you can give the answer like that by stating the section numbers with that particular subsections. So for that perspective, to remembering the section number with the title is also useful.
Okay.
Man coming to the third, yes. Yes. So coming to the chapter 3, so basic things will be clear, that what is the definitions or the interpretation of the patent, then what is not patentable. Now, if something is patentable, then what happened? So sequentially, they have given the all the chapters and the sections. So if the something is patentable, then who can apply for that? First, the applications for the patent. So who, in that they have covered the this section number 6 to 11. So in the first, they will cover the which type of the persons are entitled for to apply for the patents. So inventors can be apply, applicant can be apply, then any legal representative of them or the any assignee will be there. So they are the persons who can apply for the patent. Now then, if that thing will be decided that who can apply, now first is the patent will be eligible for the patent, invention will be, then who can apply. Now if that will be decided, then what the next, which are the forms are that which we have to file. Then in the section 8, that is specifically related to the form 3 or the foreign filing. So if any person who will file the patent application in India as well as in the PCT or the any other country, so in that case we have to file a form 3 every 6 months. We have to intimate or give the declaration to the patent office that after filing in India we have filed in the PCT or the any other country. So that is our we can say that the responsibility to say the patent office to update the patent office whether application will be applied in other country or not. If not applied, then you just write down that we have not applied anywhere, but you have to file the form 3 every 6 months to the patent office. So this for section 8, it basically related to that only. Then the forms which are where various forms are used, then in that one of the form is the form 2, which is the very important form or which covers all the technical details of the patent application. So that is that form 2 is also known as the provisional and complete specification. This both type of the are the types of the patent application. So in the section 9, they will cover about the various provisions of the provisional and the complete specification. So in that also, this section 9 is also useful for the MCQ related questions, because they have given the different scenarios in that. If, generally the two types of the patent applications are there. One is the provision, another is the complete specification. Now provisional will be filed if your invention is in the ideation stage, you have not completed your invention or the research work. So in that case, people will file the provisional. Now, if you file the provision, then you have a 12 months of the timeline. In between that, you have to file the complete. Without filing the complete, your application will not be move forward for the publication in the examination. So that is the 12 months window will be the common timeline for the all. But if that will be not filed, then what happens? So your application will be become abandoned. It will not move forward. In second scenario, they have given that if you will feel that your research work is still take 2-3 months more than the 12 months, so then what you can do, you can convert your you can apply for the post dating. That 6 month period will be there, which you can apply for the post dating. Then another scenario will be there if you directly file the complete specification and later on stage you have come to know that okay, some of the research work I have to add or the result I have to add. So in that case, you can convert your complete to the provisional. So the different type of the scenarios are there which are given into the section 9 that can be asked in the MCQ as well in the paper 2 scenario based questions. Right. Then in the this once we selected as a form 2, that is the provisional or the complete. So in that, which type of the content you have to add, that will be covered into the section 10. Then in the section 11, the priority dates of the claims of the complete specification. So generally the priority date means the first date when you have applied for the patent application. So if you have applied in India, then your filing date and the priority date will become same. But if someone will come to the India from the PCT route or by the any other foreign countries route, then their priority date will be the first date when they have applied in their particular parent country. So that whole this section they have given details about the priority date that we will cover in detail. How the priority date will be calculated, then what is the actual content of the drafting. These both things will be covered during the our post lunch session or the afternoon session, because in that we will learn about the drafting, patent drafting. So that will cover about these sections. Then once the application will be filed, then what is the next step? So it's related to the publication and the examination. So in the publication, they have given the different sections and the examination perspective. So in this, the section 11A to section 21, they are related to the publication as well as the examination. So in the section 11, and that is particularly related to publication. So generally, publication will be happen after the 18 months of the first filing date. Either it's provisional or the complete. So that 18 months is the in general common timeline. If you want to do the early publication, if you want a publication less than this 18 months of the time period, then you have to apply for the early publication request. For that, the form 9 will be there and additional fees you have to pay. So if you will apply for the early publication request, then your application will be published within a month of that particular such request, or the form the date of the filing of the form 9. After that, the within that 1 month period, your application will be published. So this is the this can be asked in the MCQ questions, which form is used. Then if you apply for the early publication, then when your application will be published. And if you are not applied for the early publication, then in the normal route, when your application will be published, right? Then coming to the examination, in that the request for examination will be there. Then the examination, how it will be for the in the Indian patent law, as per the Indian patent law, the patent application cannot be examined as such. Means if you are not request, then they cannot examine your application. In case of the research article, if we have applied for the research article, we have submitted research article, then they will automatically review and give us the feedback. But in case of the patent application, if you have applied, application will be published. But if you are not applied for the request for examination, then your application will not be examined. So it called the deferred examination system. We have to request the patent office that you will please proceed for the examination with our respect to our application. So in that, they have given the different forms are there, particular timeline will be there. That also we will learn quickly in the upcoming lectures. Then uh, they have given some search for the anticipation by the previous. Now examination request has been done. Now how patent office will be examine your application? So in that, they will check the patentability criteria, novelty, inventive step, and the industry applicability. So in the novelty, how we can search that novelty means the newness, how we can say that your invention is the new. So for that we have to search for the prior art, whether the particular invention for that the patent has been applied, whether it is available or they disclose in any of the patent or the research article or any book or anywhere else. If it is known in any of the document in the India as well as in the any of the country, then it's become a prior art for your particular application. Then examiner will be there in the patent office. They will prepare the report. The report will be checked by the controller. Then controller will give us the that examination report, and we have to respond to them. So in that also controller have some of the power to refuse the patent application and to give the chance for the amendment of that application. Then this section 16 is related to the division of the application. So in any invention, if there is a multiple invention will be there, there is no unity of invention. Means one is the product related claim will be there. Second is the process related claim will be there. So this both, if the process will be unique and the product will be unique, the both are the unique, then these both are treated as a separate application. So if you are combining both the things in the same application, then it loses the criteria of the unity of invention. So for that, controller will tell us that in this particular invention which you have applied or the patent applied, in the two inventions are there. So you have to divide those things in the two different patent applications. So that it is known as the division of the patent application. That is the another type of the patent application, divisional patent application. So sometime it will be asked that which sections are related to the division of the applications or the divisional applications. Then section 17, as I told, that the post-dating provision will be there. If your research work will not be completed within that 12 months of the period, then you can post-date your application for next 6 months. So that section 17 is related to the post-dating. Then what are the different powers of the control in case of the anticipation, infringement, then substitution of the applicant. So anticipation means if any prior art will be there which destroy your novelty or the inventiveness, then it's known as anticipation. Then infringement means if your patent will be granted and if someone is using your patent application related product without taking your permission, or so it infringing your patent application, in that controller has some of the power. Then if any substitution applicant, if the any addition or the deletion of the applicant name into the application, then what is the power or the what is the rights of the controller. And in the section 21, time for putting the application in order to grant. So when we can put the patent application for the grant, so after once patent application will file, then it's published, then it's examined. In the examination, the patent office will give us the first examination report. We have to respond to them. So that period is a 6-month period. So you can, once you will respond for that particular examination report, then there will be a hearing process. If further objection will be there, otherwise your patent will be granted. So that 6-month period will be there, from which you have to respond for that examination report. That is known as the time in which you have to apply for the grant. Is this clear?
Yes,
Anna?
so far clear. Yes.
Yeah. I'm just moving forward very speedily because this is just the basic overview for the whole the Patent Act. If anytime you will feel that something confusion will be there or query will be, you can interrupt me.
Thank you.
Yeah. Now, the chapter 5, that chapter 4A is omitted as, now as per the latest amendment. Then in the chapter 5, that is particularly related to opposition. So this whole chapter we will go in the deep today's session. So that we will learn after completing of this quickly revision. So we are moving forward to chapter 6, that is related to the anticipation. Now, anticipation, as I told, that if any patent application or research article or review article, any document which are either patent or non-patent literature, or anything which will be become a disclosure for your patent application or your invention. So that become that is known as the anticipation. Now they have given the whole the chapters. This chapter is very much important, as in these chapters many scenario based questions can be asked. So in that they have given the different type of the anticipation. by which type of the documents or the disclosure will be there. Based on that, they have divided the sections in the different anticipation categories. So in that, if any previous publication will be there, so in that case, how we can come out from that disclosure, or how can we can prove that that our invention is not as such disclosed in that. So that is related to publication. Then if anything which we have previously communicated with the government by the way of any exhibition or any conferences, so any government conference or the symposium will be there, at that time we have disclose our invention or the research work to them, then what happened to our invention, whether it's treated as a disclosure or not. So that provision is also given in that. Then in the public display means you have presented or the your model or the prototype in front of the any conference or seminar or the webinars to the government or the any other authorized body. So in that also what the things. Then in the public working, if the any invention which are related to that in which the public working is required, let's for example any if any civil related invention will be there, civil engineering related invention, in that they are making the roads, right? Now in that when they are making the roads, they are using the particular type of the material which give the high strength to the roads in the rainy season as well as in the very high heat. So that particular material they have to check into the public domain because the roads are in the public domain. So in that, when you are taking that public trials or the public working, then what happened, whether that the things will in front of the publics, then it will be disclosed. Then what happened to the application, if that application will be filed for the particular invention on which the public trials or the working will be taken. So in that they have given some of the provisions. Then the if the publication after the provisional application, then what happened, and this last section is that if something will be there, then it's not tag as a anticipation. So as such, anticipation means your things, your inventions, the things which are related to your invention are disclosed priorly. That is the main meaning of the invention. But in this chapter, by this different way of the disclosure, they have given that how you can come out from that invention or your disclosure. So basically this is the remedy by which if the publication will be there, if you have already communicated with the government, if any public display will be there, public working will be there, then how you can come out from that and you can move forward for your patent application towards the grant. So basically they have given the remedies over here. So in general, if anything will be disclosed by any of that, and within that the date of the public working or the date of the public trial or the date of that previous communication or the conference, then any publication, if anything will be there from these sections, and within that 12 months of the period, if you will apply for the patent, then these things will be not act as a prior art for your patent application. So that 12 months period is known as the grace period, and that can be also asked in the MCQ related questions. Are there in the any patent in the patent law of the India? Is there any provision will be there which extend or which is known as a grace period? So yes, that provision will be given into this chapter, and that is the 1 year of the period or the 12 months of the period. And in this case, the section 34, they have given that if any user publication after the provision application, you have applied for the provision application, anyone other also applied for the patent application for the similar invention like you, but they have directly applied the patent application, and once you have applied for the provision, then you have 12 months of the time for the complete specification. Now in between of the 6 months, if that another person's application will be published, so you don't know that, right? Because they have applied earlier, but public they're not, that application will be not published, so that is not in the public domain. So how you can search that? You can search in the Google or the any patent offices, but if the application will be not published, then it will be not showing anywhere. So you cannot come to know that whether it's published or not, or that similar invention applied or not. So in that case also, that scenario things will be given into these sections. Clear this anticipation?
Yes.
Then this chapter related to the secrecy directions of the certain inventions. So some of the inventions which are related to the defense purpose. So in that case, if someone will be filed the patent application for that defense related inventions, either it's a product or process or any device related things, but that particular related to the defense, then that particular inventions will not be published. It will be communicate with the central government that such type of the application received from the such applicant, and that is related to the defense. Then the government will be look into that whether it's actually related to the defense or not, and it's related to the defense, then it will be helpful for the Indian defense system or not. Then if it's required for the Indian defense system, then government will be personally involved in these cases, and the things will be moving onwards. And if they're not that much of the important, then that secrecy direction we can call as this thing that will be removed. So the things which they have given, they hold the details over here, that how the secrecy direction will be implemented on that, how it will be reviewed, then when it will be revoked or they stopped, then what is the now if that is secrecy direction will be on that particular defense related invention, then the whole the timelines which are related to publication or the examination that may be crossed, right? So in that they have given some specific extension for that particular inventions, because the government has stopped the things, right, for the publication and the examination. So for that they have given some of the extension related things. Now in the section 39 they have given that if any person who will who wants to file the patent application other than India, outside the India, but they don't want, he or she don't want to file in the India. So in that case, they cannot directly file into the US, Europe, or any other country without taking any permission. So for that, we have to take a permission from the patent office that we are not filing the patent application in India. We are directly wants to file into the US, Europe, and any other country. So give us the that permission. So that for that also they have given the particular timeline, and after the receiving the permission from that, the person can directly apply for the other country's patent, or the timeline if that they have not responded that permission, and the timeline they have given into the act, if that will be completed, then after that that completion of the timeline, people will apply for the patent application outside the India. So for that, the particular the main reason why they have doing this type of the things. So if the any defense related invention will be there, right? So if that application will be treated as a normal application, then it will be published after 18 months, or if the early publication will be there, then it will be published within the 1 month. Now once the application will be published, is come into the public domain. If it's in the public domain, if any other country's defense system or any other people who to come to know that okay, this type of the defense related invention will be there, that will be published into the patent, so they will try to use or modify to use, right? To so to keep these things in the secret manner, they have added this whole the provisions. And in this case, if anything which are related to defense or any other the invention which are related helpful for the Indian people or the country. So in that case, if they will directly file into the other country, then the application will publish over there, and it is available to the whole the public domain. So that things will be not be remains secret. So for that type of the things, they have added this provision. If things which are related to the defense or related invention, then we have to refer this section. Clear this?
Yes.
Then the another chapter related to the grant of the patent and the rights. Now the whole the examination will be happen. First filing, then publication, then examination anticipation will be there. If secrecy direction related application, then what happened? Now patent is at the stage of the grant, last stage. So at that time, the basic details they have given about the grants. Then if the any disease applicant will be there, then how we can amend if the patent will be granted. Now the applicant of that particular patent is the die, then what happened, that things they have given, then date from where the date will be start, then what is the effect of that form and extent, then means the patent is the territorial right is limited to the India only. Then in the certain conditions patent will be granted. So in certain conditions they have some of the government conditions are there, like in the as we know that the pandemic situation, right? In that some of the that remdesivir, as you know, that is a very critical molecule and is required much more during this COVID related pandemic situation. So if that will be protected by the way of the patent, by some any other country in the any other country or the India. So they cannot as such using those things in the India. So for that cases also government give the some of the conditions to grant the patent application or for the research purpose, right? Then the if the patent will be granted, then what is the rights of the patent? So the generally based on the rights of the patentee means the applicants after grant becomes a patentee. So the patentee, if there is a four patentees are there in the particular application, then in that scenario, if they have not signed any agreement, then they have equally divided rights will be there. So if the four applicants are there, so 25% each will be given to them. And if any particular agreement will be there, then based on that, the rights will be given. Then if one person wants to sell the patent application or wants to give the license, then what are the rights? Then all the things will be given into this section 48. Then patent rights not infringed when the this is related to that if any vessel will be there, any ship will be there, which accidentally or temporarily moving to the patent in the India. But for that, the patent application will be filed. So if that particular product which are shipped into the ship or the any vessel, foreign vessel, and they are passing through the India as a temporary thing, or they accidentally they have passed through the India. So in that case, that particular product will not infringing the rights of the patent application. Then what are the rights of the co-owner if will be there? Then if the co-owner will be there, if some dispute will be happening between them, then what are the rights of the control to give the suggestions or the direction to the co-owners? Then the grant of the patent application for the true and first inventor. Sometime what happened, people will not add the name of the true and first inventor and they have applied for the patent application. But later on state that true and false inventor come to know and they have that much of the proof and they will prove that I am the true and first inventor of this particular invention. Then the patent will be granted on that term. Then the terms of the patents means the 20 years from the first filing date, that is the term of the patent. So whole the when how the patent grant, what is the rights for the patent, and what is the term and date of patent. This all the things will be covered into this chapter. Then one more type of the patent application. One is the provisional, second is the complete, third is the divisional patent application. Now fourth is the patent of addition. So what is the patent of addition? So generally, if you have applied for the patent, patent has been granted, or you have just applied for the patent. But after that also you are come up with some improvement in that. So for that improvement perspective, you can apply for the patent of addition. And now in the term of the patent of addition, so that is similar to the this patent of addition is known as the child patent. So that is remains the same as the parent patent. Then what are the validity for that patent? We don't need to pay the additional renewal fees for the patent of addition. So the whole the details about the patent of addition that will be given into this chapter. And generally the MCQ related questions or multiple choice related questions are asked from this chapter. Then coming to the amendment of the patent applications, first we have applied provisional list, for example, then we have applied the complete. Then later on states some objection will be there during the examination phase, and we have to amend the claims as well as the specification. So in that, how you can amend, what is the limitation, there's all the things they have given into here, that if you the amendment before the controller means during the examination, then amendment before the appellate board and high court if your patent has been rejected or your patent has been revoked, or so for that the amendment will be taken in front of the appellate board and the high court. But as of now, appellate board is dissolved now directly. First the patent will be applied to the patent application, then patent will be published, examined in the grant in the patent office. If patent will be refused by the patent office, then the case directly moves to goes to the high court and then the Supreme Court. Similarly, there is in between, previously there is the one IPAB will be there, appellate board will be there, that will be formed inside the patent office only, and first they will check there whether how the patent will be rejected and all, or the for the revocation perspective. And after that, that will be goes to the high court and Supreme Court. But as per the latest amendment, appellate board will be dissolved now, so now directly the things will be goes to the high court and the Supreme Court. Then the supplementary provisions will be there. So in general, if any amendment means we are changing the specification of the patent application or the claims. So in that, only three types of the amendments are allowed. CDE, we can say correction, disclaimer, and the explanation. Correction means somehow instead of the methanol, you have some in the sum of the part you are written the ethanol, but actually you are using the methanol. So in that you can correct that the M will be. I have forgot to add the M in the sum of the paragraph or the claims. So just as I have added the methanol in the many of these the sections of the patent applications. So now I'm just correcting the things. So that is related to correction. Then disclaimer means if any prior art which are cited for that the methanol is used in the previously, but you are using the both methanol and ethanol. You have taken the trials on both, so you can disclaim that okay, I'm claiming the patent application for methanol for ethanol only, not for the methanol. So we are disclaiming means we are not claiming, that is becomes a disclaimer. And in the some case it's a related to the explanation. So CDE, explanation means some type of additional data you have to give if the patent office will ask, and that. So in the CDA format only the amendment will allow. You cannot add the new things into the patent application before the grant or the after the grant. Clear this?
Yeah, can you repeat the C part again?
That is correction.
Yeah,
Correction, disclaimer, and the explanation.
totally.
And coming to the this next chapter, restoration of the lapse patent. So now what happened? Patent has been granted. Some amendment will be there or not. That is a different thing. Now once patent has been granted, we have to pay the renewal fees till the 20 years. So if you are forgot to pay the renewal fees for any of the year, then your patent becomes a lapsed. Lapsed means there is now you don't have a rights for that patents. So if your patent will be lapsed, then if you want to restore that patent, so for related to things they have given over here. So if your patent will be lapsed and you can prove that unintentionally I have forgot to pay the renewal fees, or some reason that that reason is also satisfactory, and that is unintentional. I have not made these things intentionally not to pay the renewal fees. If you can justify those things, then you can apply for the restoration. So that restoration means the lapse patent will be again restored. So related things they have given over here, within what period you can apply for the restoration, what is the form for that, what is the fees for that, what are the grounds for that, that is unintentional undue delay, or your why you have the reasons why you are not applied, not pay the renewal fees. Then if your patent will be restored, then what is the rights from that date of the cessation, we can say seized or the lapsed are the both the same thing, date of the cessation as well as the restoration. So in between there is no rights. So if someone is starting using your application, patent application or product or the process, then what are the rights you have applied for? You can file a infringement suit or not. So that all the things they have covered over here in the restoration. Clear this? Yeah, it is clear. This restoration related things. Sanjay, your voice is not audible to me. Not. Can you please again speak? No, yet not. You can also drop a message in the chat box that okay, okay, we will move forward. Then coming to the surrender and the revocation, now patent has been filed, renewal fees has been paid. If not paid, then what are the sections for that? Now, what happened in the surrender and the revocation? These both are the very important things. This revocation related chapters we will cover in the upcoming classes. and in that time also and the surrender. So now surrender means what? If any person wants to surrender their patent, so in some of the cases they can, if some if patent application will be revoked or not infringed by some any person, so in that case also they will surrender that, okay, my patent application is already uh, revoked by some other things, so better I will surrender those patent applications. So that related to things, they will be covered into section 63. And the revocation related, the revocation means if your patent application has been filed, published, examined, grant, now you have if you have patent granted, then what are the rights with you? That you can manufacture, you can sell, you can market, you can import, export your your product, patented product or the process, right? Now, and one another rights with you is that you can stop others to making, using, selling those particular patented product or the process. So if you are stopping others, and still the people will be using your patent application to prepare the particular patented product, so at that time they are infringing your patent. We can say the word, legal word is infringing. So once that other people will infringe your patent application, you can file a legal suit against them that I have this right and they are now infringing about my patent application. So once you have applied for the infringement suit, then that particular other party will counter file a suit to revoke your patent application. That is the patent application. There are multiple grounds are that patent application is not a patentable, then it's not a novel, it's not inventive. Other different grounds are there. So based on that, that other party will counter claim or the counter suit filed for the revocation. And if that other party will be proved that whether their patent will be fall in this revocation related grounds, then patent will be revoked. Means after that there is no rights with you if your patent will be revoked. So in that we will learn in detail in the upcoming classics about the revocation. Then the register of the patent. So in the register of the patents, uh, the now patent has been granted. Now what details are there that will be in the register of the patent? That is known as the register. So which things are available into that? What things we can get details from that? So that whole the details they have given over here. Then the patent or the chapter related to the patent office and its establishment means the who are the controllers and other officers, what are the patent office, different branches are there. That is a four patent offices are there: Mumbai, Delhi, Kolkata, and Chennai. Then one more that is known as the Patent Information Center, that is situated based on the Nagpur. Then what are the restrictions for the employees of the patent office? Then how they cannot provide some of the information, because the information related to the patent is also confidential information. Then in the another chapter, they have given about the powers of the controller generally. The controller will be there, the highest having authority, having the highest authority. So in that they have some of the powers or the rights in case of the any civil court related things. Then the things related to the clerical errors. Then any evidence required, any disposal, so any extension related time. So the things which are the different provisions of the patent act, in that what are the rights and the role of the controller, that is given in this chapter. Then this next chapter is also very much important in that is related to the compulsory licensing and the revocation and
See,
working of the patent. Yes.
are you scrolling the page? Cause I am not able to see the moving screen. Did you scroll the screen?
Yes. Is
I,
it?
I am I'm still being able to see the screen of chapter 9, 10 and 11 only.
uh, what are the sections are there?
Yes, I can see the sections, but I can see only chapter 9, 10 and 11 only. So did you, I just wanted to know if you scrolled below.
Yeah, I am scrolling there. Is it there? The section 82 will be showing to you.
No, I can see last section that I can see 64.
Okay. Let me again share the screen.
Okay.
Now
Oh
it is
yes,
that.
now I can see 82 to 105.
Okay, okay. So you have
Yeah.
seen till the 66. In, previously, you have seen till the 66, section number
Yes,
66.
yes, yes.
Okay, so
But
after that, we will cover these three.
yes,
The
sure.
right
I
register
can
that patent
recollect.
office
Yes, I
and
can
yeah,
recollect.
yeah. Then this chapter is very much important, which are related to the working of patent and compulsory license. So basically, in journal, I will just summarize the whole the chapters. Generally, what happened once you have applied for patent published, examined, and granted, then there is no such provision is that once you will get the patent granted, then you will keep with you. Okay, I have a granted patent, and I'm enjoying the monopoly. I'm stopping others, and I'm also not using the patent application. I'm just telling that I have a patent. So that is not allowed as per the patent law. You have to work your patent in the working manner. So if as you are from the pharma background, right? So if you have applied for any product or the formulation related patent, so you have applied patent and your patent will be granted. Then as you are not come up with the any product into the market or in the research scale, or you are just write down the things into the pen and paper, and that from that particular patent you are not generating the revenue or not commercializing your patent application, so that is not allowed as per the patent law. So the working of patent is a must. Once your patent will be granted, then you have to every year you have to give the form 27 to showing that your patent will be in the working stage, or you are still finding investors, or still your patented product is in the R&D phase. So that thing you have to justify it. But your patent application will be in the working stage, that you have to intimate or update the patent office every year. So that is the one thing. Now, second is the compulsory licensing. So if your patent is not in the working stage, then what happens? So there is the 3 years timeline will be there. If after the grant also, if the till 3 years, if you are your application or your patented product is not in the working stage, then any other person, means if you are from pharma, I am also from pharma, right? You have a patent rights, but you are not come up with the working of the patent application till 3 years of the date of the grant. So now I am from the same field. I have a enough capacity to manufacture your patented product, right? So for that I can apply to the patent office that this patent is not worked in the working condition, but I have this much of the facility. I can make this product, this patented product, and sell those product to the Indian community with the very affordable price. So for that, if you are not in the position to make your product in the working stage, then any other party can ask patent office for the compulsory licensing. Now, compulsory license, why they have used the word compulsory, means it is not a voluntary. You are not voluntarily giving the license to me. That's why I have to approach the patent office to take a license for that particular product. So that is related to compulsory license. They have given the some of the provisions on which basis you can apply for this compulsory license. What are the timelines will be there? What are the forms will be there? Then if your that license will be given to you, so what are the different types, or the we can say the characteristic of that license that cannot be assignable, that cannot be exclusive license, like that. So that whole things they have covered over here. What are the terms and conditions for that? Then license for the related patents they have given. Then if that compulsory license, when it will be terminated, that is given for the particular limited period of time. So within that limited period of time, if you are come up with that, now I have enough facility to manufacture my product, and please terminate this license. So that can be given into the section 94. So the whole the things. And the revocation means if your application will be in not in the working state, then any other person can apply for the revocation to revoke your patent application. That application has been granted, but that is not in the working state still the long time period. So it's need to revoke for that. So that also covered over here. That will cover in detail in the upcoming classes, because this is a very important chapter. You can refer those things from the recorded session also for your basic knowledge, but we will cover this section in the later on classes. Then the next chapter related to the use of the inventions for the purpose of the government and the acquisition of the invention by the central government. So in some of the inventions are that in which government will be involved, like the defense. One we will see that defense related invention. Another is pharmaceutical related inventions. As you know that in the pandemic, remdesivir is a very much needed product. So in that government will involved and government will tell the patentee that you will please keep the price low and manufacture the lot many in the very high lot because is the requirement of that particular invention is more. So the which are the invention in which the government will be used, what are the power of the government for that, what are the rights of the third party for that, then how the government will acquire do the acquisition within that particular inventions. These all the things will be covered in this chapter. Then the next chapter is related to infringement. Infringement means what? If you have a patent rights, you have a patented product or the process. Now I am preparing the same product or preparing the different product from the patented process, same process which you have get a patent. So in that scenario, you can file a legal suit for me that without taking any permission or licensing from you, I am using your process or the product, and by that way I am infringing your product. So you can file a suit on me for that. If I will see that that some of the loopholes in your patent application will be there, so I can file a revocation suit again, counter suit against you. Then what are the jurisdiction for that? Then who have to a burden of proof, who have to prove that the infringement will be there or not, and what are the rights for that, if exclusive license will be there, then what are the things, then who is the scientific advisor. So all the details which are related to the infringement or the legal proceeding which happens into the court, either high court or the district court, the whole the things will be given in this chapter. Then appeals to the appellate board. As of now, this appellate board, I have told that this appellate board, IPAB board, is dissolved now in the patent office, but still this section will be here. So we have to learn this section and we have to just go through these sections. Then which type, what is the appellate board, who is the staff for that, what are the procedure and the cost, or there's all the details they have given into the appellate board. Then next is related to the penalties. Penalties, some of the rights are there in the patent office. If they can be violated, then penalty will be there. So in that, if the falsification in the entry in the register, if any false entry will be there in the register, or any unauthorized claim of the patent rights, then any wrongfully using the patent office word, then any the patent agent which is not registered or not the person who is not a patent agent who is doing a practice as a patent agent, then what are the penalties are there. Then any companies who is doing any offenses, then what are the offices are there. If your patent is not applied or not granted, you have just in the ideas instead, and if you are telling that my patent this product is patented or applied for the patent, but the actually patent will be not applied for that, then also you are eligible to pay the penalties. So in penalties, there may be imprisonment for the some years, 2 years, 3 years, and also the case penalty will be there. You have to pay the some case in the form of the penalties. Then the things which are related to the patent agents, so that they have given the whole the details about the patent agents. So what is the register for that? In register, what details will be available? What are the qualifications are there? What are the rights are there? Then how the subsequent verification will be there, then restriction on the practice as a patent agent, how the if the patent agent's name will be for the patent agent also. Once your examination will be clear, you will become a patent agent. Every year you have to pay the renewal fees. If you forgot to pay the renewal fees, your name will be removed from the patent register. So in that case also, if there will be removed, then what is the procedure, how you can restore that name, what are the controllers power with that patent agents. So all the things which are related to the patent agents, that is given in this chapter. Then in the international agreements, so in the international agreements, they have given the different conventional countries, who are the conventional countries, which type of the applications are conventional. So generally, the two type of the international applications are there. One is the related to the conventional country, a conventional application. Another is the PCT, Paris patent cooperation treaty. So conventional means within the 12 months of the period of the first filing date, you have to apply the conventional application in the particular conventions under the Paris Convention. So if you want to apply for the this US, then within the 12 months period of directly you have to apply to the US, then Europe. So the timeline will be a lesser in the Paris Convention. Now in the PCT is the whole the platform which you have to apply for the patent application within the 12 months period. But after that, you have a 30 to 30 months period, 31 months of the period. Within that, you have to decide whether you want to go to the US, Europe, and another country or not. So this both type of the international applications are there related to the things. The related to the conventional applications, they have given the details over here. For the PCT, they have given the whole the separate chapter in the rules form type. Now in the miscellaneous, the things which are not covered into any of the sections of the above chapters, and that is also useful that all the different sections are covered in these miscellaneous chapters. So in all the recorded session, we have completed till this section 163. So you can refer any of the sections and any of the chapters from the recorded sessions. Meanwhile, some of the important chapters are there that we will cover in the upcoming classes. And once you will refer all the recorded sessions and reading the things, if you will feel that if any query will be there, and if you want to learn any of the specific section, so you can tell me or the Hamaxi, we will learn you those sections.
Sure. Thank you.
Right. So